These are the absolute bottom line issues that you need to know about the pistol brace rule. We are just days away from it going into effect and perhaps turning millions of law-abiding Americans into felons thanks to ATF flip-flopping. My office has been getting flooded with phone calls, as have the comment section of my emails, asking largely the same kind of set of questions. This is the video that you all wanted. Let's go. By far, the biggest question that's blowing up my inbox is this. Tom, can I just take the stabilizing brace off the pistol and then store it or whatever, and am I fine? And according to the initial rule that dropped back on January 31st, the answer to that was basically no. The ATF said that you can permanently remove and dispose of or alter the stabilizing brace such that it cannot be reattached. So taking it off wasn't good enough. You then either had to destroy it, get rid of it, or alter it and mutilate to such a degree that you cannot reattach. Okay. I mean, not okay, but that's what they said. Then back on April 26th, ATF Director Dettelbach testified before Congress and said, look, there's also the option of detachment. I'm going to put his exact quote. It's super choppy. I'm not going to read it, but his exact quote will be in the description box below. He said, look, you can detach it and store it separately. Okay, that's what he said. So a lot of people are like, oh, okay, well, that makes sense. I can take it off, store it to the side, wait for what I think is going to be a hopeful victory eventually arising from the courts, but Lord knows when. And then at that point, you can reattach it. Great, God bless, wonderful. But then the ATF on May 22nd sent an email to FFLs where they reaffirmed their position that no, you can't do that. What ATF Director Dettelbach testified before Congress, ignore. He was either lying and wrong, or he just was ignorant and didn't really know what the rule actually said. Either that or the actual ATF FAQ, as well as the recent email that just got sent on May 22nd, is incorrect. Either way, they are contradicting themselves. For those of you who are longtime followers of the ATF, this will come as no surprise. Just keep sipping your coffee. For those of you who are new to this game, first time, huh? Here's the one thing I want to stress, is that if you're going to take the braces off, I think that that's going to be an okay solution, but you want to make sure that you do not run into any kind of constructive intent, so-called, really it's constructive possession issues. The case is U.S. v. Thompson Center Arms, which was a U.S. Supreme Court case that I've covered elsewhere on this channel. I'll also link that long form in the description box below. The gist to it is this. You have to make sure that if you have a bunch of devices that could be assembled into an NFA firearm, that you have to make sure that they can also be assembled into a lawful configuration. And the ATF actually bears this out on their FAQs as well. I will link again in the description box below, quote, an NFA firearm need not be assembled to be regulated as such. Whether a person may be in constructive possession of an NFA firearm depends on the facts of the particular case. And again, this is a reference to the U.S. v. Thompson Center. So if you are keeping all these devices together, if you're keeping your pistol and your pistol brace together, Thompson Center case, U.S. Supreme Court case from the early 90s says you can do that. It's risky, but you can do that provided that there is a lawful way to assemble those together. Okay, so you need to make sure that there is a lawful configuration of the pieces. What you cannot do, according to U.S. v. Thompson Center, also hinted at by the ATF FAQs, is you cannot have the pile of parts, even if it's completely stripped down and disassembled, I mean, down to every last little detent, you name it, on your lower receiver, if you're an AR guy, then you cannot make sure that it can only be assembled into a illegal configuration. So if you have a pile of parts, there has to be a lawful configuration that can be reached in there. That's U.S. v. Thompson Center. Now, again, that does fly in the face of what the ATF has said. The ATF's rules, in my view, not only contradicts exactly what their director said on April 26th, but they also directly contradict a U.S. Supreme Court case. So at the end of the day, look, you're going to have to need to do your own research and measurement. That's what you're doing here right now. The way that I'm going to be treating this for myself is the fact of, look, U.S. Supreme Court said as long as there's a lawful configuration, okay. Now, the safer way of doing it, because I mentioned that it's a little risky to leave it so that there's potentially illegal configurations in there. If you really want to make sure that you take this out of really what's a black and white area, but just the same, it may not stop the ATF or some other law enforcement officer from hanging you up on it, is take the pistol braced stock and put it in an area completely segregated and removed from your firearms so that it cannot be assembled into anything. That is the safest way, and I can't believe that we have to get into this, but I guess welcome to ATF Law 2023, but that's the safest way of doing this, okay? And again, if you really want to take it the extra layer, then go to what the ATF has said, destroy or modify the device. I'm not saying you should do that. The keyboard commandos I know are going to come at me in the comments section for literally just reading what the ATF is saying. I'm not adopting that as my own position, but there you go. Couple other options you can do and questions I've been getting is, well, Tom, can I just switch the upper so it's longer than the 16-inch barrel? Remember, in order to be an SBR, a short barrel rifle means that it does not fit both of the criteria for being a rifle. In other words, you need to have a 16-inch or greater barrel, and you need to have an overall length of 26 inches. Keep in mind that may vary from state to state according to how they measure it. Michigan used to have an odd way of measuring it, but generally speaking, from maximum overall length if you have a telescoping stock or folding stock or something like that. But check your local listings on that. Yes, you can switch to a longer 16-inch or longer barreled upper, but you also need to make sure that you still meet your 26 inches or greater overall length. So if for some crazy reason you have a 16-inch barrel, but your overall length is 25 inches, that's still a short barrel rifle. So you need to make sure that you still achieve that overall length of 26 inches or greater, okay? Well, after I register, can I unregister it? Yes, you can. After I register it, if you're going to go the eform route, after I register it, can I switch uppers? What if I want to switch from an 11-inch upper to a 10-inch upper or a 14-inch upper? Yes, you can. The safe answer is you should send a letter to the ATF to notify them about it. The gist to it, as long as you don't change the nature of the weapon, you are going to be fine, and you need to retain the original upper that you registered with. Okay, so if you have a particular 11-inch upper, don't trade or get rid of or dispose. The very safe answer is if you go to the range, if you go out to the field or whatever it is that you're doing with that, bring that upper with. And I know that's inconvenient, but long story short, if you want a deeper dive analysis as to where all this information is coming from, let me know in the comment field below. But long story short, keep the original upper, but you can change the uppers provided you do not change the nature of the weapon. So you cannot go to a destructive device, so a caliber greater than 1/2 inch, and you also cannot change it to a shotgun. So no, because it's registered as an SBR if you went the eform route. An SBS is different, so that's bad. ATF will not like that, okay? As a reminder, if you are going to be going the eform route, keep in mind you need to file 5320 if you're going to travel interstate. You also can't just sell it like a normal firearm. You also have to deal with co-dominion issues. So you can't just leave it on the line and walk away to go to the bathroom or something else like that without potentially running into issues. And last but not least, NFA gun trusts. I have all sorts of people reaching out to me for NFA gun trusts. Guys, it is too late for NFA gun trusts on this. According to the ATF, they will only allow you to eform register this to an NFA trust if you can show that the trust was in lawful ownership of the device, of the pistol, I'm going to call it a pistol, when the rule dropped back on January 31st. So trying to get an NFA gun trust in March, April, May, no good, too late. You have to show proof that it was registered at that time to the trust, that the trust owned that. And again, you have to follow the trust laws in your state as to how you add property to the trust. Generally speaking, it's probably just making sure that it's been added to your Schedule A or whatever particular document basically is the ledger for the property that's inside that trust. It may or may not need to be notarized. Again, check your local listings for all that kind of stuff. Yes, there's also discussion about 27 CFR 47.11. That's the Code of Federal Regulations. That's where all these rulings from different agencies like the ATF, DEA, EPA, and so forth, this is where they go to live. They go to the CFR. So if you're wondering, hey, where does this go? It goes to 27 CFR 478.11, which is, and then scroll down to the rifle section. I will link that in the description box below. And if there's space, I'll also include a copy paste of that in there as well. You can see their factoring criteria in there. Guys, before I give you my closing thoughts, please take a moment to help this video get out there. Click like, show your support for the Second Amendment. Also, of course, make sure you don't miss any of our future content. Please consider clicking subscribe. And also, just as a reminder for those of you who are interested, there's also membership options as well. If you click that join button, there's 3 different tiers, and there's going to be basically extras. We're not taking anything away from the channel, but we are giving extras, extra content, extra exposure, and so forth for folks who do choose to support us in this endeavor. So we appreciate that. Guys, my closing thoughts on this. I think that this is going to wound up being struck down eventually. For those of you who are followers of this channel, you know what happens when I go chainsawing trees up north. I am scheduled to be going up north, and I will be chainsawing next week. In other words, right as this whole thing, or as this whole debacle is me going into effect. I didn't schedule it on purpose that way, but there is some serendipity there. I will also note that the attorney that we've interviewed on this channel, attorney Lucas Weber from the Wisconsin Institute for Law and Liberty, fantastic group, fantastic guy. Check out that interview because he's filed a fantastic lawsuit in the Northern District Court of Texas. No, it's not the one where the judge declined to issue the preliminary injunction. This is a case that we're still waiting for that judge to issue an injunction on, and he could be waiting for he's hopefully waiting for the very last minute at this point to take action. So there is still a ball in the air here in order to stop this from going through. We appreciate you sticking around this long. I will see you in the comment section below. As always, we'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.